This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes appears with his attorneys, Ms. Brady, Ms. Nelson, Ms. Higgs, Ms. Spengler, and Mr. King, and the prosecution is represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, Ms. Stitch McGuire, and Mr. Edwards. The record should reflect that we are outside the presence of the jury. I have a few things on my list of housekeeping issues. The first thing that I want to do is ask counsel if they received the latest, what should be the final draft of the instructions, which my staff emailed yesterday at about 5 o'clock. Did the people receive them?
We did, Your Honor. We have no objections, additions, deletions, modifications, or suggestions.
Okay, and no additional instructions to tender?
Correct.
Any objections or any additional record you want to make with respect to the verdict forms?
No, Your Honor.
All right. Did the defense receive the instructions and the verdict forms, Ms. Nelson?
We did.
Okay. Any additional record or objections or any additional instructions that you want to tender?
I do have just a few things, Your Honor.
Okay.
You may just have just a moment.
Yes, and for the record, I'm referring right now to the introductory Phase 1 instructions, the final Phase 1 instructions, and the introductory Phase 2 instructions. Those three sets. Those are the sets that my staff emailed the attorneys late yesterday. And for the record, I've made the changes that I said I was going to make. Ms. Nelson, go ahead.
Your Honor, first I just want to make clear for the record that we continue to object to the language that the court included in the instructions about the merger. We don't believe that the language that the court added solves the issues that we raised to the court's attention yesterday or ameliorates the harm, and we maintain our previous arguments with respect to that issue.
What else?
And then the second thing, we did discuss this, but in reviewing it last night, I have an additional proposal on this issue. It is on page, just one moment. The court's introductory instructions to Phase 1. Let's see here. Pages 8 to 9, the bottom of page 8 into the beginning of page 9. It's this sentence: if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, it must either 1, return a unanimous verdict of life imprisonment without the possibility of parole, or 2, notify the court that it is unable to reach a unanimous verdict. I know we objected to this the language distinguishing between a unanimous and a non-unanimous verdict, but as I was looking at it again last night, it also occurred to me, based both on the prosecution's proposed verdict form for Phase 2 as well as the verdict form that we intend to propose, which we haven't yet submitted to the court, that either way, whether it's a unanimous verdict for life without parole or a non-unanimous verdict, they'll be able to indicate that on the verdict form, or they should be able to indicate that on the verdict form. It's not that there's no place to indicate a non-unanimous verdict on the verdict form and that therefore they have to notify the court. And so I was wondering, we would like to propose that the court rephrase that just slightly to state as follows: if the jury is not unanimously convinced beyond a reasonable doubt that death is the appropriate punishment on a particular count, it must indicate on the verdict form that it has either 1, reached a unanimous verdict of life imprisonment without the possibility of parole, or 2, that it is unable to reach a unanimous verdict. In either situation, the defendant will be sentenced to life imprisonment without the possibility of parole on that count. And that at least would make it clear to them that in either situation, they can indicate that on the verdict form.
What's the people's position, Mr. Orman?
Your Honor, I think that the instruction that the court distributed adequately conveys to the jury their duties and their options, and I don't see the need for any change.
And I'm not too concerned about it, because even if I end up agreeing with you later, Ms. Nelson, if we get to phase 3, and this would only come into play if there is a phase 3, otherwise it's moot. This is part of the introductory instructions, and it's part of the introductory instructions that talks about phase 3. I can still do the verdict form the way you're asking me to do it, and it would not be inconsistent with this. Either way, they would be notifying me, whether they're notifying me through a note or notifying me through a verdict form. Either way, they would be notifying me that they cannot reach a unanimous verdict, if that's the situation. So I'm not too concerned about that, and I think it leaves all of our options open still if there is a phase 3 and you still want to argue that point. And I think it's a point that has some merit, and I'm not saying that I'm going to go that way, but I might. So, and we've already made copies of all these instructions at this point. So I don't think that's a concern that warrants redoing all of the instructions and copying them again. This was in there, by the way, in yesterday's draft, and this particular suggestion was not brought up before we finalized the instructions. Ms. Nelson, is there anything else at this time?
I have one other matter on the final instructions for phase 1. It's the last instruction that begins following the attorney's arguments at the end of phase 1. It's the last sentence of the first paragraph, which currently reads, "Your foreperson will preside over your deliberations and shall sign the part of a sentencing hearing phase 1 verdict form according to the rules that I am about to explain." I think that should read, "Your foreperson will preside over your deliberations and shall complete the sentencing hearing phase 1 verdict forms, plural, according to the rules I am about to explain."
Again, I don't think that's a substantive issue. That point is made clear later in the instruction, so I'm not too concerned about that. By the way, I changed that particular sentence as you suggested yesterday, so it appears now exactly as you asked me to leave it or to have it. So again, the instructions have been copied, and I don't think that particular issue warrants making that change and then copying all the instructions again. Mr. Orman, do the people have a position on that?
I agree with Your Honor.
Okay. Is there anything else, Ms. Nelson?
No, Your Honor. Not with respect to the instructions.
Okay. Since there was an issue that we discussed quite a bit, actually, not only yesterday but Monday, with respect to merger, let me make a supplemental record related to that. Because yesterday at the end of the session, I said that I would look at the authority that was cited by Ms. Nelson, and then I would decide how to proceed. And the record will reflect the changes that I made from the draft that we were working with yesterday to the final set of instructions, not only the introductory phase 1 instructions, but also the final phase 1 instructions. I read Caldwell versus Mississippi, which is cited at 472 U.S. 320, 105 Supreme Court 2633, 86 Lawyers Edition 2nd 231. That's a 1985 case from the United States Supreme Court. That decision, in my view, is inopposite. In that case, during rebuttal closing argument, the prosecutor argued that defense counsel, that the defense attorneys were attempting to make the jurors believe that the jurors were going to kill the defendant, but that defense counsel knew that the jurors' decision would not be final because their job was reviewable. The trial court overruled the defense's objection to that argument and stated in support of his overruling the objection that it was proper that the jury realize that its decision was reviewable automatically. The prosecutor then added that the jury's decision was automatically reviewable by the Supreme Court. The United States Supreme Court vacated the defendant's death sentence in Caldwell, holding that the need for reliability in the imposition of a death sentence mandated the conclusion that it is constitutionally impermissible to rest a death sentence on a determination made by a sentencer who has been led to believe that the responsibility for determining the appropriateness of the defendant's death rests elsewhere. Relying on Caldwell in People versus Drake, 748 Pacific 2nd, 1237, that's a case from the Colorado Supreme Court from 1988, the defendant asserted on appeal that some of the prosecutor's comments during closing argument so diminished the jury's sense of responsibility that reversal of his death sentence was mandated. And by the way, Drake was another case that was cited by Ms. Nelson yesterday. Although the Colorado Supreme Court in Drake found that the prosecutor's comments were susceptible to several interpretations, it concluded that it was highly likely that they injected an element of confusion for the jury. The court added that without clarification from the trial court, they may well have resulted in a diminution of the jury's sense of responsibility for the ultimate imposition of sentence at the critical stage in the proceedings, when consideration of the appropriate punishment was the task immediately at hand. Because the prosecutor had implied that the jury had only an indirect or advisory role rather than the ultimate role in the imposition of the sentence, the Colorado Supreme Court ruled that the comments from the prosecutor were improper. Now, the court in Drake did not find that the improper comments by the prosecutor were dispositive of that appeal. To the contrary, the court specifically said that they were not. However, the court ruled that these comments constituted a factor which, when considered in conjunction with other problematic issues, cast doubt upon the reliability of the defendant's sentence. Unlike the situations in Caldwell and Drake, here, we're not dealing with comments made by a prosecutor during closing argument. More importantly, the draft Phase 1 introductory and final instructions that we worked with yesterday did not in any way cause confusion, much less diminish the jury's sense of responsibility in deciding the defendant's sentence. In any event, however, and in an abundance of caution, I made changes to both sets of instructions after the hearing yesterday to make it completely clear that the jury has the sole responsibility for the defendant's punishment in this case. I left the explanation about the merger issue in the two sets of instructions to address the concerns that were expressed by the defense on Monday in terms of there being some aspect of unfairness or prejudice if I don't tell the jury about merger and if I allow the jury to have the impression that there are going to be 24 convictions in the end with 24 sentences. So I went ahead and left the discussion in both sets of instructions related to merger, but I made it abundantly clear that the jury has sole responsibility for punishment and that whatever sentence is imposed in this case, it'll be the jury's sole decision. Additionally, again in an abundance of caution, I went through both sets of instructions and deleted references to the court imposing the sentence in accordance with the jury's sentencing verdict. I don't think that language is confusing. I don't think that language in any way expressly or impliedly diminishes the jury's understanding of its role in this case or the jury's role in this case, but in an abundance of caution, I went ahead and took that out as well. Yesterday, the defense made an additional argument with respect to the issue of merger and in support of its request to have the court merge the counts now and only submit 12 counts to the jury. The case that was cited was United States versus McCullough. That's capital M, small c, capital C, U, L, L, A, H. That is a 10th Circuit Court of Appeals case cited at 76 F 3rd, 1087, a case from 1996. The argument that was advanced is that allowing the jury to deliberate on all 24 counts of murder in the first degree in any phase of the sentencing hearing improperly allows the prosecution to double count its aggravators. I find McCullough in opposite as well. In McCullough, the 10th Circuit Court of Appeals held that the submission of duplicative aggravating factors is constitutional error under the weighing scheme of the federal death penalty statute. But in that case, the trial court allowed the prosecution to submit two sets of aggravating factors that substantially overlapped with one another. Not surprisingly, the court found that such double counting of aggravating factors, and when I say the court found, I'm talking about an appeal. The court found, that the 10th Circuit found, that such double counting of aggravating factors, especially under a weighing scheme, has a tendency to skew the weighing process and creates the risk that the death sentence will be imposed arbitrarily and thus unconstitutionally. In stark contrast to the situation in McCullough, here there's not an assertion, much less a showing by the defense that any of the alleged aggravating factors overlaps with another aggravating factor. Therefore, there's no double counting. What the defense really complains about in this case is that there are two counts for each murder that was committed by the defendant. That is a completely different circumstance than what was before the court in McCullough. And I'm not concerned about the circumstance present in this case because I'm instructing the jury that it must treat each count separately. In other words, with respect to each count, the jury is going to have to first decide if the prosecution has proven beyond a reasonable doubt at least one of the alleged aggravating factors. If the prosecution does so, then each juror has to determine with respect to each separate count whether there are any mitigating factors. And if so, each juror, again with respect to each separate independent count, must independently weigh the mitigating factors against the aggravating factors. Only if each juror concludes beyond a reasonable doubt that the mitigating factors do not outweigh the aggravating factors with respect to a particular count does the hearing move to phase 3 on that count. And then in phase 3, each juror would have to use his or her reasoned moral judgment to decide what sentence is appropriate with respect to that count. Significantly, the weighing process, again in this case, must be separate with respect to each count. That is a significant circumstance here, and it is something that I'm telling the jury specifically about. I'm instructing the jury specifically about. So if the prosecution, for example, were to prove 4 aggravators with respect to one count of murder, the jury would be limited to those 4 aggravators on that count. If the prosecution were to prove the same 4 aggravators with respect to another count of murder related to the same victim, the jury would still be limited to those 4 aggravators as it relates to that other count. There's no double counting just because there are 2 counts for each murder. Each count requires the jury to go through the sentencing process I have outlined, separate and independent from other counts. Given the instructions that I'm providing the jury, I feel very confident that the jury will not blindly or unthinkingly add up the total number of aggravating factors and weigh that number against the total number of mitigating factors. If the jury were to do that, it would be in violation of my instructions, and the law assumes that the jury follows the court's instructions. In any event, in an abundance of caution, I added to the introductory Phase 2 instructions some language that was specifically suggested by the 10th Circuit Court of Appeals in Davis versus Executive Director of the Department of Corrections. That's cited at 100 F. 3rd 750, 10th Circuit, 1996. Ms. Nelson mentioned this case yesterday in our discussion. In that case, the 10th Circuit Court of Appeals observed that an instruction that the weighing process is not simply a mathematical exercise, but instead requires critical evaluation of the factors can help to countervail any improper influence occasioned by the submission of duplicative aggravators. The mathematical part was already there, as counsel know, that part was already in the instructions, but I added the part about the requirement for a critical evaluation of the aggravating and mitigating factors. The next thing that I have on my housekeeping list is C-TR-92. Yesterday, there was a discussion with respect to this exhibit. I think we had a brief discussion about it on Monday as well. This is the statement from witness JJ, I believe is her name, and the people objected through a motion in limine to her testimony, and I sustained the objection. I had not reviewed the report. I made my ruling based on the offer of proof that was made here in the courtroom, but in an abundance of caution, I wanted to read the report in its entirety. I did that yesterday. My ruling stands. I think that this witness would be able to testify about two different things. Number one, she would be able to testify about her own character and her own background, not the defendant's character and background. So that evidence of her own character and background is inadmissible because it is irrelevant. The second thing that this witness, based on the report that I reviewed, would be able to testify about is some type of reverse victim impact evidence or some type of victim impact type evidence. This is different than execution impact evidence. I ruled in Order P52 about execution impact evidence being inadmissible. This is more about the impact that the crimes had on the defendant's mother. And again, as real as that impact may be, and I don't question it, she's not a victim in this case under Colorado law any more than the defendant is a victim in this case. So that is not victim impact evidence. I'm not aware of any authority that allows that type of evidence to be introduced. So I wanted to make sure the record showed that I had reviewed that report, and I continue to believe that it is irrelevant and inadmissible. And I think it's a little different than execution impact evidence, which is what Order P52 dealt with. The next thing on my list had to do with the media question request that the defense had made at the end of the day yesterday. And I had proposed a particular question, and then after I proposed that question, the defense came back with a different request. And I'm not sure that the record was completely clear as to whether the defense would rather not have me ask that question or whether there's a different request. It seems to me what would be appropriate is for me to tell the jurors, and here's what I would propose, for me to tell the jurors that I've been giving them an admonishment throughout the trial, throughout the proceedings, that they are to avoid any exposure to media reports and news reports. And to the extent that despite their best efforts, they have inadvertently been exposed to news reports about the case in the past, or that they ever are in the future, that they need to let one of my bailiffs know about that. And all they have to do is tell my bailiffs that they need to talk to me. That would be one question. The other question would be similar and would be, I have been giving them an admonishment throughout the proceedings that they are to avoid visiting any locations mentioned in the proceedings. And to the extent that even despite their best effort, they have inadvertently visited any location, or to the extent that that happens in the future, they need to let my bailiffs know that they need to talk to me about something, and then we can address it at that time. That way I don't put them on the spot by asking them the question here in court, and they can have some time to think about it, think about whether either of those circumstances has happened. I think in the discussion we had about this yesterday, the defense referred to some kind of event that took place to mark the 3rd anniversary of the shooting. And I don't know if that took place at one of the locations mentioned in the proceedings, and therefore the second question would take care of that, or if the defense wants me to add a third question along the lines of, to the extent that you've ever been exposed to an event related in any way to this case, or that happens in the future. To the extent it happens in the future, let my bailiffs know that you need to talk to me. So I'm happy to ask either the two first questions, or I'm happy to, it's actually not questions. I'm happy to make the first two advisements, but I'm also happy to make the third advisement if the defense wants me to, in terms of saying event. But I don't want to say event unless the defense wants me to do it. I agree with the defense that we have to be careful not to call more attention to this, and so I can't say the 3rd-year anniversary or anything like that. But I think if I say event, then that hopefully covers it, and hopefully it's vague enough and general enough that it is not problematic. But I'll only do that third part if the defense wants me to. So Ms. Nelson, you or whoever, or Ms. Brady, do
Thank
you have a
you.
position on that?
Your Honor, we'd prefer you not say event. We would suggest the court tell them that if they've inadvertently seen or received any outside information concerning the case from any source, to let the court know.
Do the people want to be heard on this, Mr. Orman? Okay. I think that's appropriate, Ms. Brady, so I will ask that, or I will say that as well. The last thing I have on my list of things to talk to you about before I bring the jury in is the request that people had made before deliberations in the guilt phase of the trial for a 3-hour delay or a 3-hour waiting period. I don't think it's necessary at this point, and I would be inclined to do 20 minutes to save time. I think the defense has 4 witnesses that it is attempting to call today to avoid any scheduling issues. And I think people have notice now, if they want to come here and be here, they can get here now, or they can get here around the noon hour if they wish. I don't think we need to wait 3 hours. Do the people agree?
Can I just consult with some of the victims who are present in the courtroom?
Yes, please.
Your Honor, I believe from what the court was saying that would apply to this phase. And we would have a different discussion, I think, at a later phase. Is that correct?
Yes.
That's fine with us, Your Honor.
Okay,
And it's
great.
fine with the victims who are present in the courtroom.
So is 20 minutes okay, or, yeah?
Yeah,
Okay,
that's
well,
fine.
is that okay with the defense, 20 minutes?
Yes.
Does that give your folks enough time to get here?
Yes.
Great, okay, let's do 20 minutes. All right, is there anything else we need to talk about on behalf of the people before I bring the jury in?
Your Honor, one thing occurred to me this morning, that there may be certain items of evidence that were admitted that in their totality have a limited purpose for their admission. And therefore, I wonder whether those items of evidence should go back with the jury for this phase. And what I'm specifically thinking of is the notebook and the discs containing the statements that the defendant made to Dr. Reed. Those are the only exhibits that I remember for which a limiting instruction was given. There were other exhibits that were entered where the witness's testimony had a limiting instruction. However, I don't recall a specific limiting instruction for the exhibits.
I think Dr. Fenton's medical report.
Then hers is that as well, Your Honor. And I don't know if the defense has any other ones that they think should not go back, but those exhibits I do not believe have any relevance or use to the jury for phase 1 of the capital proceeding. And it's an unusual circumstance, Your Honor, but I think because of that they should not go back with the jury when they deliberate in phase 1.
The only other thing I can think of was Dr. Metzner's CV, I think, was admitted, but I don't think that makes a whole lot of difference. That's just the CV. I know that the instruction was given without objection with respect to other evidence. For example, I remember the the DVD of the defendant before he was brought into the courtroom in September of 2012, I gave the limiting instruction with respect to that DVD as well.
I think that should be included then in any list of items that don't go back with the jury. I can't think of any others at this point, but and I don't there was the jail writings, the galactic colonization writings. I don't think that they would have any relevance to this proceeding, but I don't recall whether either party requested a limiting instruction for that one. But if the defense would like those not to go back to the jury for this phase, I certainly would agree with that.
All right, who wants to address the court on this issue? Do you have any, first of all, do you have any objection to these items that we have identified, Ms. Brady, not going back to the jury room for deliberations?
No, sir.
All right, and do you have any additional items that you would like me to exclude from deliberations?
No, sir.
Okay, great, thank you. All right, we will not send back the notebook, the discs containing the statements to Dr. Reed, Dr. Fenton's medical report or medical notes. I should say medical notes, I think that's easier, or that's more accurate. And then the DVD of the defendant before he was brought into the courtroom in September of 2012 while being held in one of the holding cells here in the courthouse. That one should not go back to the jury room for deliberations either. Is there anything else on behalf of the people, Mr. Orman? No. All right, is there anything on behalf of the defense, Ms. Brady?
Yes, sir. Your Honor, I gave your clerk a copy of a PowerPoint presentation that was provided to us by Mr. Orman. It's a 129-slide PowerPoint presentation. It was provided to us at approximately 5:51 last night. I would note that this is the second time a lengthy PowerPoint presentation has been given to us on the eve of an argument. We would object to the PowerPoint in total. I would object to the color, content, the size of the writing, the choice of the words, the pictures, the entire content of the PowerPoint presentation. As the court is aware, having heard the trial and the merits in this case, none of the evidence in aggravation is disputed. Not a single item of evidence supporting their aggravation is disputed. So I think that having a dramatic PowerPoint like this is unduly inflammatory, irrelevant, and unnecessary, particularly given the heightened reliability of a capital sentencing proceeding. I do have specific objections to specific slides if the court wants me to go through those at this point.
Please.
Slides number 8 through 33. So slide number 8, Your Honor, is the one that says 1, Jonathan Blunk.
Yes.
And goes through slide number 33. Those are slides that have the victims' names and their photograph, followed at the end by a compilation or a collection of all of the photographs together, thereby repeating all of the photographs again. We would object that this is an improper use of photographs to evoke emotion and sympathy from jurors. It's improper victim impact injected into phase 1 of the capital sentencing. We litigated the scope and propriety of all victim impact evidence already, and it's only to be introduced at phase 3 if we get there. In addition, there's no need for photographs to be published twice to the jury, so we would object if they're admitted at all. We would object to them being shown twice. We would cite the court to Colorado Rule of Evidence 401 and 403. Although these photographs have already been admitted into evidence, we would object to this particular use of the evidence, and also cite the court to People versus McBride, McBride, 228 Pacific 3rd, 216, a Colorado appellate case from 2009, dealing with Prosecutors may not pressure jurors by suggesting that guilty verdicts are necessary to do justice for a sympathetic victim. Next, I'll move to slide number 36.
Okay.
This specifically is the repetitive showing of the picture of Veronica Mosier Sullivan. I think it's shown 4 times in total by itself or in a collection. So we would object to the repeating of that photograph. Also, it's not, these photographs, and particularly this one, is not needed to prove the aggravator. Again, improper victim impact, cumulative, and the probative value is substantially outweighed by the risk of undue prejudice as regarding their closing argument. We would again cite 401 and 403. Slide 38. That's the slide that states, the evidence shows you that the defendant had the conscious objective to kill every living soul in that theater, man, woman, and child alike. We would object to the phrase living soul, for living soul is not an element of the aggravation, not something that they have to prove as part of aggravation. It's improper, inflammatory language. It's also not an argument that's based on the evidence. We believe it misstates the law. In order for the jury to find the existence of this aggravator that this slide deals with, the prosecution has to prove that it was Mr. Holmes's conscious objective to kill a child under 12, that he specifically intended to kill a child. And the aggravator cannot be satisfied by finding that he intended to kill anyone or everyone and just ended up killing a child. There has to be the intent to kill a child specifically. And sentencing is about personal moral culpability. The aggravator doesn't satisfy the Eighth Amendment's narrowing function if it just applies to someone who has the intention to kill everyone, but then just happens to kill a child. Aggravators in general are premised on the notion that it is a fact or circumstance about the crime that makes the defendant more culpable. So in order for this aggravator to be satisfied, Mr. Holmes would have had to have actually intended to kill a child, not just happened to kill a child. So we would object to that slide, citing Rule of Evidence 401, 403. Regarding case law on the purpose of aggravation, we would cite the court to Lowenfield, Lowenfield versus Phelps, Phelps, 484 U.S. 231, quoting Zant, Z-A-N-T, versus Stevens, S-T-E-P-H-E-N-S, 462 U.S. 862, and People versus Davis, a Colorado case 794 Pacific 2nd, 159. Case law regarding inflammatory language, Harris versus People, 888 Pacific 2nd, 259, Colorado 1995, and People versus Walters, 148 Pacific 3rd, 331, Colorado appellate case from 2006. Moving to slide 39. Again, Your Honor, I think I mentioned that. That's another photograph of Veronica Mosier Sullivan. Slide 42. As in the Merritt's case, where we objected to any sort of doctoring or marking on an exhibit, we would again object to the marking on this exhibit. It's an arrow pointing to something on a picture of Mr. Holmes with the gear on. So we would object under those same arguments. We also object because I think this photograph is confusing to the jury. The jury knows that this photograph was taken at Mr. Holmes's apartment, that it dealt with all of the incendiary devices and equipment that was contained at the apartment. As the court knows, that scene, that count is not relevant to the aggravating factors, and I think it would confuse the jury, and we would object under those grounds. Next slide, number 43. Photograph of a gun laying in with blood spattered around and the flip-flops that have been testified to. We think that this slide is an improper use of the evidence to evoke sympathy and emotion from the jurors, and we would object under those grounds. Slide 49. That's the slide that says at least 76 shots. We would argue that that's a misstatement of the evidence. Particularly the second sentence that says at least 670 individual projectiles. I don't recall that being testified to in evidence, not sure where that figure came from. If they took all of the different fragments located and added all those up, I don't know if that comes up to 670, but we do not know where that figure came from, so we would object that it's a misstatement of the evidence and misleading based on the trajectory testimony that was given by their witnesses in the merits phase. Slides 66 to 91. Your Honor, these are some of the injured victims and pictures of some of their injuries. It's some of the more gory photographs that were admitted to the jury. Again, I would reiterate that none of those injuries were disputed. None of those victims were cross-examined concerning their injuries. In closing argument and opening statement, at no point did we dispute the injuries or in any way put any evidence on to try and contradict any of that. And simply displaying these photographs, again, photographs that, granted, Your Honor, the jury has in evidence and will have with them, but there's no need to display them during the prosecution's closing statement in this capital sentencing. We argue that their use is simply to evoke emotion and sympathy from the jury. It's not needed to prove the grave risk of death aggravator. Again, it's improper victim impact injected into phase one. It's improper victim impact for injured victims. As the court knows, the victim impact at the sentencing hearing will be limited to the deceased victims, and so evoking sympathy and emotion related to these injured victims is improper. We believe that there's a risk that the jury is going to make their sentencing decision based on the injured victims instead of on how they're instructed by the court concerning the first-degree murder counts. For this, we'd cite, again, Rule 401 and 403, that the use of this evidence has a different purpose at sentencing, and we would object to the way it's being used in phase one of this capital sentencing. Slide number 99. And that begins with, consider the defendant modified the environment of his killing zone by deploying tear gas. Is the court there?
Yeah.
Okay. Your Honor, we would object to this slide. We would object to the phrase killing zone. That's an improper inflammatory term, not based on the evidence presented by witnesses or evidence at the trial. We would again cite Rule 401 and 403, Harris versus People, 888 Pacific 2nd, 259, People versus Walters, 148 Pacific 3rd, 331. Slide 101. This means victims would experience extreme discomfort from the tear gas in addition to being shot. We object to this slide. It expresses an improper personal opinion of the prosecution. It's not relevant to any alleged aggravator. It's not the logical inference from the evidence. We would cite the court to Domingo, D-O-M-I-N-G-O, hyphen Gomez, G-O-M-E-Z, versus People, 125 Pacific 3rd, 1043, Colorado case from 2005, concerning prosecution's remarks during closing argument expressing personal opinion are improper. Slide 103, the defendant killed his victims in a crowded movie theater. Same objections as to slide 101. It's a personal opinion by the prosecution, inflammatory, and particularly inflammatory is the use of his victims, framing it in the possessive way that it's framed. We would object to that slide under the same authorities that I cited for slide 101. Slide 104, the victims were trapped by design. This is argument based exclusively on evidence that has been excluded from the jury's consideration at this stage of the sentencing hearing. And namely, it seems to be based on the notebook and statements made by Mr. Holmes to Drs. Reed and Metzner as to why he chose the movie theater. The court's instructing the jury they may not consider that evidence at phase one, and we believe that this slide and the slides through 108 are based on this excluded evidence. We would cite Colorado Revised Statute Section 16-8-107, the right against self-incrimination under the Fifth Amendment, and Article 2, Section 18 of the Colorado Constitution, as well as due process, right to fair and impartial jury, right to a fair and reliable sentencing hearing, Fifth, Sixth, Eighth, 14th Amendments to the U.S. Constitution, and Colorado Constitution, Article 2, Sections 16, 20, 23, 25. Three cases we would like to cite: Estelle, E-S-T-E-L-L-E, versus Smith, 451 U.S. 454 from 1981. Powell, P-O-W-E-L-L, versus Texas, 492 U.S. 680 from 1989. Satterwhite, S-A-T-T-E-R-W-H-I-T-E, versus Texas, 486 U.S. 249 from 1988. Slide 105, they were unable to flee. We would object to this slide being inflammatory and not based on the evidence presented. Slides 106 through 108. Knowing that every breath could be their last in the darkness and that there was nothing they could do about it. We would object that this series of slides injects personal opinion of the prosecution and hypothesizes about the victim's mental state, a mental state that's not properly in evidence from the first trial. We would object that it's inflammatory and improper appeal to the jurors' emotions and is tantamount to asking the jurors to put themselves in the victim's shoes, and we would object to such an argument. Slide 110. The defendant killed his victims so that it begins.
Yes.
We would object that this is not a fair inference to argue from the evidence, that they cannot attribute intent and purpose to Mr. Holmes. To do so is to use the statements that he made during the sanity evaluations in an improper manner, as the court has instructed the jury. They are not allowed to consider, and so we would object again under the same authorities that I cited for slide number 104, his right against self-incrimination, and the Estelle and Powell cases that I cited earlier. I would object to the, I think it's the next slide, but all of the slides that repeat the word torturous again and again, we would object to that. Slide 112, the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish. We would object that this is improper opinion testimony by the prosecution, improper inference from the evidence as to what was Mr. Holmes's intent and purpose. Again, to the extent that it is a valid inference, it's based on evidence that the jury is being instructed not to consider, specifically Mr. Holmes's notebook and statements made to experts during the sanity examination. I would cite to the same authorities I cited to earlier concerning the Fifth Amendment and the Estelle, Powell, and Satterwhite cases that I cited earlier. Slide 117 through 120. Consider the victims were unaware of any danger, watching a movie, helpless. The defendant was in a place of concealment. That series of slides we would object as improper opinion, argument, and comment on the evidence, repeating the argument that any inference that comes from this based on Mr. Holmes's statement during the sanity examination should be excluded. They should not be allowed to argue based on information that came from those statements by Mr. Holmes. Slide 123, the victims had no way to know that danger lurked right outside. We would object to this slide using inflammatory language, improper appeal to jurors' emotions, and for the term lurked, we would cite the court to People v. Walters, 148 Pacific 3rd, 331, a Colorado Court of Appeals case from 2006. Those are the specific slides in addition to the general objection to the entire PowerPoint. All of my objections are pursuant to Mr. Holmes's right to due process, right to a fair and impartial jury, right to a reliable sentencing hearing, the 5th, 6th, 8th, 14th Amendment to the United States Constitution, Colorado Constitution, Article 2, Sections 16, 20, 23, 25. Also, I found some state cases. We might have cited one of these during the merits PowerPoint objection, but I would cite the court to a couple state cases that talk about use of PowerPoint or misuse of PowerPoint presentations by the prosecution. State versus Reineke, R-E-I-N-E-K-E, at 337 Pacific 3rd, 941. It's an Oregon case. And State versus Hecht, H-E-C-H-T, 319 Pacific 3rd, 836, a Washington case. Can I have just a moment?
Yes.
And one more case, Your Honor, in the matter of Edward Glassman, G-L-A-S-M-A-N-N, 286 Pacific 3rd, 673, a Washington case. Thank you.
All right, thank you. All right, new rule, folks. From now on, if you want to use a PowerPoint presentation, you have to tender it to the other side 2 days in advance. And if you want to object, you have to make the objections a day later. Got it? We can't be doing this. I mean, the jury's waiting. This is unfair for the jury. I've encouraged you folks to share information with each other in a timely fashion, and you folks insist on waiting till the last minute to do it, and you're both doing it. And now, you want me to rule on about 50 objections while the jury's waiting to come in here. It's not fair to the jury. It's not fair to the court. It's not the way things should work. This is not the way things should work. So, who wants to respond from the people?
Your Honor, I understand the court's statements. However, I would note, I gave this to the defense as soon as I finished it, and I know Your Honor was a trial attorney for a long time and knows that the preparation for an argument happens up until the argument.
We're going to have to delay things then. What's going to happen is we're going to end evidence in a particular phase, and before we can have argument, we'll wait 2 days so that you can prepare your PowerPoint presentation, and then the other side can object. That's how it's going to go. I mean, we just can't keep doing this. And you're both doing it. You're both using PowerPoint presentations. I find it interesting that the defense is making global objections to PowerPoint presentations when they themselves have been using them. That's inconsistent. I mean, the defense, hold on, I heard you, now hear me out. The defense used a PowerPoint presentation in closing arguments as well. And I hadn't seen the defense's PowerPoint slides in closing when I ruled on some of the objections to the people's PowerPoint presentations or PowerPoint presentation slides. And what I realized as I was listening to the defense's closing argument is that some of the same issues that the defense was complaining about were things that were included in the slides that the defense used. Not all of them, but some of them. Some of the very complaints that the defense made about the people's slides were present in the defense's slides. So, you're both using PowerPoint presentations, and we can't do this where we wait until the last minute and then there are objections, and then there's going to be a response, and now I have to rule on a bunch of objections, and there has been extensive authority cited, all while we're waiting for the jury to get in here. All with the understanding also that there's time pressure because there are witnesses the defense wishes to call today who may not be available after today or may have some scheduling conflict. So it is unfair to the court. It is unfair to put the court in that type of position. And the only way that I see around this is to put time limitations on you. So if you want to use PowerPoint presentations, do it 2 days before you have to do them. In other words, you have to serve it on the other side 2 days in advance. And then if you want to object, you have to make the objections the next day so that I can have time to look through the PowerPoints, think about the objections, look up any authority that I need to look up, and then make rulings. All right, Ms. Brady, I'll get back to you. Let's let Mr. Orman finish. Mr. Orman, go ahead.
Well, Your Honor, thank you. I appreciate the court's ruling. I didn't know if the court was saying that I did something wrong by providing it to Ms. Brady last night. I was just trying to explain why that happened. The use of PowerPoints is accepted in courts in the United States. Used to be attorneys would get up and write things on boards. And if I can write it on a board, I can put it in a PowerPoint. This is just a more effective way to do that. I don't think I need to say anything else under the general concept of me using a PowerPoint. And I know the defendant objects to me apparently arguing for the existence of aggravating factors, arguing to the jury that they should find beyond a reasonable doubt that we have proven the existence of aggravating factors, because that's what we have to do. Ms. Brady talked about things being non-contested. Well, if they don't want to contest anything, they can stipulate to the existence of these aggravating factors. Otherwise, I've got to ask the jury to find that we have proven these aggravating factors beyond a reasonable doubt, which as far as I know is the highest burden that anybody has in the law in the United States in any court anywhere. So I've got to ask them to find these beyond a reasonable doubt. And I'm using the evidence that was admitted in the trial and reasonable arguments based on inferences from that evidence for them to do so. The first aggravating factor, that he killed more than 2 people in the course of the same criminal episode, yeah, I'm using their names. Those are the people he killed. I'm using their pictures. Yeah, I'm using their pictures, Judge. Those are the people he killed. That is the evidence in support of that aggravating factor. I have to ask the jury to do it beyond a reasonable doubt. And at the end of that sequence, yeah, I would put them all together again to show the number of people he killed. That's an aggravating factor that we have to prove. There's an objection to the term living soul. And frankly, to that argument, well, Your Honor, we've had evidence. We had a woman named Chi-Chi Sproul who came in here who said she had never seen so many children in a movie theater in her entire life. And she didn't want to sit next to children, but it was hard for her to even find a place away from children in that movie theater. And the evidence shows with the amount of ammunition that this defendant took to that theater, with the number of rounds he had on his person, with the weaponry he had, it was his intention to kill everyone in that theater. And the term living soul, Your Honor, I think is just a colloquial term for everyone in that theater. It is not unduly prejudicial to the defendant. It is reasonable argument for me to make that argument and for me to use that term. He saw children in that theater. We had Corbin Dates testify that there was a baby in the same row as the defendant. He intended to kill everyone in that theater, and it is a proper argument for me to make that therefore he intended to kill a child under 12 and did so. That is the nature of my argument. And I would also note, counsel makes objections to these as if they are the totality of my argument. The purpose of these slides is to illustrate some points I am making, but by no means is this all the argument I would make. It accompanies my argument. Your Honor, regarding their objection to the slide that shows the defendant with the rifle strapped to his chest.
Before you get to the rifle picture, there was an argument right after the argument related to the every living soul. And the argument is that one of the aggravators requires you to prove beyond a reasonable doubt that the defendant intended to kill a child. And it can't be the type of situation where he just happened to kill a child without intending to kill that specific child. Your response to that is what?
My response to that, Your Honor, is, well, first of all, I don't know that he has to intend to kill that specific child. I think he has to intend to kill a child under 12 and do so. And here we have both. Because he was in a crowded theater. We have had people, it's not my fantasy that it was crowded, as Ms. Brady would somehow argue to the court, where there was evidence from multiple witnesses that this theater was packed. We have evidence from multiple witnesses that there were many young children including a baby, in this theater. We have evidence that the defendant went into this theater with enough ammunition to kill everybody in there. And we have evidence that the gun jammed, and that's why he didn't. So he went in there with the intent to kill everyone in that theater. He knew that there were young children in that theater. It is a reasonable inference from the evidence that therefore he went in with the specific intent and acted with the specific intent to kill a child under 12. The evidence supports that aggravating factor. The evidence supports that argument. And additionally, Your Honor, he shot Veronica Moshe Sullivan 4 times. It's hard enough to shoot a person once. He shot a person 4 times. He shot that little girl 4 times. I think that shows the nature of his intent. So that's my response to that, Your Honor.
There was a picture before the picture that you were about to talk about when I interjected, and that is the picture you were about to talk about has to do with the firearm and some blood and a sandal. The picture right before that, slide number 42, has an arrow pointing to some gear, apparently. What's your response to that objection?
Well, Your Honor, I recall the Glassman case that counsel cited, and it was cited in the argument that was made in the first phase of the trial. And that argument was that, well, first of all, this picture shows the defendant with the gun he used to kill the people, on his chest. You can see it right there. And the aggravator here is that he knowingly created a grave risk of death. Well, this is evidence that shows what he knew what he was doing, and he knew what this was. The objection to the arrow, Your Honor, my understanding of the objection based on Glassman, and frankly, Your Honor, I think that there's nothing wrong with us putting an arrow on top of an exhibit to point something out. If I can go up and put my finger up to it on the monitor, there's no reason I can't put an arrow there to make that point. But I haven't done that here because of the court's ruling in the previous phase. I put that arrow completely outside the photograph. That arrow does not in any way modify that exhibit. It is next to the photograph, pointing to the side of the photograph where that gun is. So I have not modified that exhibit in any way, shape, or form. I'm just pointing out something on it.
Okay, the next one is 43.
The next one is 43. That's a picture of the gun that he used that was found at the scene. It's the same gun that he's shown in his photograph, holding right at his chest, strapped to his chest. It is the weapon he used that shows he knowingly created that grave risk of death. Same is true with the other weapons. The same is true with the photograph showing all 3 of them together.
I think the objection, if I remember correctly, to the picture of the firearm and the sandal is that under 403, it's unduly prejudicial and unnecessarily inflammatory for purposes of this phase 1 because it shows blood and it shows a sandal, and that's not relevant to what you're trying to prove in this particular phase.
Well, I beg to differ with that argument, Your Honor. He created a grave risk of death by shooting folks. And this is blood by one or more of those people that he shot. That shows that it is evidence of their injuries. It is evidence of the grave risk of death that he created. So I beg to differ with that argument.
The next one is slide number 49, and the objection, as I remember it, is that it misstates the evidence. That's the one that says at least 76 shots, at least 670 individual projectiles.
Well, Your Honor, if you look at my previous slide, I have there the rounds that were found in the theater, and counsel didn't argue that was inaccurate. I believe that's accurate. That is 65 .223 rounds. Each of those is a projectile. That is 5 .40 caliber rounds. Each of those is a projectile. And then you have 6 shotgun rounds, each with 100 pellets. Each of those pellets is a separate projectile. We've heard from people that we've seen the images of how those rounds created those patterns of all those holes. Each of those is a projectile. And my math is that adds up to 670 individual projectiles and 76 shots. That is a reasonable inference based on the evidence. And the reason I say at least is that's just what was found. Who knows if some shell or something got kicked into a little area where no one was able to find it.
Okay, the next objection I have is to slide 66 to 91, which show injuries to the surviving victims or some of the surviving victims. What's your response to those objections?
Your Honor, I think I could have shown, and I would have been reasonable in doing so, photographs of every injured victim. every injured victim in that theater because the defendant created a grave risk of death to all of them. And not only all of them, everybody in Theater 9 and everybody in Theater 8. The defendant created a grave risk of death to each and every one. And I am taking a few of them out here to demonstrate to the jury the nature of the defendant's conduct and how he created a grave risk of death, and showing some of the injuries that he caused by his actions, creating a grave risk of death to these people. So there is no improper inference or improper argument related to any of these photographs or the mention of any of these people.
The next one I have is slide number 99, and I believe the objection is specifically to the use of the term killing zone.
Well, the defendant's been convicted of killing 12 people in that theater. The jury's found he killed them. So the term killing, I don't see how that's objectionable or inflammatory. He did it. They found he did it. The zone is, he killed him in this zone, the theater. I don't think the term killing zone is some type of term that is unnecessarily inflammatory. It's just a descriptor of what he did and the area that he did it in.
The next one is slide number 101, which deals with, I think, an argument that this means the victims would experience extreme discomfort from the tear gas in addition to being shot.
Right. So
And the objection, I believe, is that it is opinion, not a logical inference from the evidence.
Well, Your Honor, it's not only not that. It is direct. There's direct evidence of this, not even circumstantial evidence. We have direct evidence from numerous people who described what the tear gas did to them and what they went through because of the tear gas this guy chose to deploy in the theater. So it's a reasonable inference based on that anybody else in that theater is going to experience similar discomfort. That's not just me making that up, as Ms. Brady might try to allege.
The next one I have is 103. The defendant killed his victims in a crowded movie theater, and I think the objection was to the use of the word his.
Your Honor, he killed them. He's been convicted of killing them. They're the victims. They're his victims. I don't even understand what the argument is there.
The next one I have is to slide number 104. The victims were trapped by design, and the objection is that this is an argument based on evidence that has been excluded from this phase of the proceedings because it's based on the defendant's statements during one of the court-ordered sanity examinations.
Well, Your Honor, it's not. And, this is one of those circumstances where this is to accompany an argument that I am making. The design I am talking about is him going in with the tear gas, deploying that, him going into a place where it's really crowded and nobody would be able to get out of there easily because of the situation he is creating, the design that he's going into a dark place where there's a lot of noise from the movie and so forth. All of that demonstrates his design. It is not in any way connected to the statements that the defendant made to anybody in the course of a mental status examination. I would make this argument if we didn't have that information because it's obvious from the evidence that the jury has that they are allowed to consider in this phase.
The next slide is 105, or the next objection is to slide number 105, which I think talks about the victims being unable to flee. And I think the objection is that it was inflammatory and not based on evidence.
Your Honor, I don't even know what to say to that. We've heard the testimony of what was going on in that theater from so many people. There was gunfire. People had to hide from that or attempt to protect themselves. They couldn't flee. There were so many people there that you couldn't get over other people. It was a small, dark space filled with panicking people that was intentionally created by the defendant. So I don't really even understand what the argument is there. It's such an obvious fact.
The next objection is to slides 106 to 108, knowing that every breath could be their last. I think the objection to that is that it's a personal opinion. That's what I wrote down. There may be other statements in there, but what I wrote down is that particular quote.
Well, Your Honor, it is a reasonable inference based on the evidence that we have heard what people were going through in that theater, what the situation was. Even if we hadn't heard from people in the theater as to what was going on in there, with the situation that the defendant intentionally created by going in there and shooting people in the crowded theater, the jury can make a reasonable inference that anybody in that situation would think that every breath could be their last, that they were in the darkness and that they knew that there was nothing they could do about it. That it was a reasonable argument based on the admissible evidence in this case.
And what's the relevance of that?
Well, the relevance of that, Your Honor, is the proof that we have to prove that this is unnecessarily torturous. You know, it's not like the defendant went up to someone, shot them in the back of the head, and they didn't know anything was coming and they didn't feel any pain. The defendant created a situation intentionally where these people would be in fear of their lives. And really, what's worse than that? You know, oh my God, I might get killed. You're cowering in the darkness. You know you're going to get killed. That is intentionally creating mental anguish in these victims and intentionally creating a torturous situation for them.
The next one is slide number 110, and I don't have a whole lot of information on 110. Maybe you wrote down more notes than I did. Let me find it.
Your Honor, I think that's the one that starts with the defendant killed his victims so at the moments of their deaths.
Yes.
Well,
It says the defendant killed his victims in a manner so that the victims would... Oh, wait, no, that's not it.
I think it's two before that.
Yeah, the defendant killed his victims so that at the moment of their death, they would not only be in fear of their own life, but in fear for the lives of their friends and family and loved ones.
Yes. Well, Your Honor, that is not my opinion. That is a reasonable inference based on the evidence. It goes to the unnecessarily torturous language that is in the instruction provided by the court, which is based on a precedent from the United States Supreme Court. The fact that he did this, he was in that theater. The evidence is he would have been in that crowded theater, seeing people surrounded by their friends and family and people that they came with. And, you know, Your Honor, it's not like you go to a theater and everybody comes alone. You know, you see people talking. The jury can make a reasonable inference about what's going on in that theater and what the defendant saw. So he would have seen that people are surrounded by their families and then killed them in a manner so that when he was shooting his gun, everybody in there would not only be concerned about their own life, that's pretty bad, but even worse probably, concerned about the lives of the people they're with, and being helpless to do anything about it. It's like taking a mother and her child into a room and saying, oh, I'm going to kill you, but first let me tell you I'm going to kill your child, and pointing a gun at the child's head.
The next objection is to the use of the word torturous.
It's in the instruction, Your Honor, and I do repeat it because I go back to the instruction, and it's language I've taken directly from the instruction so that I can demonstrate to the jury this is related to that factor that you need to consider, unnecessarily torturous, so that I can argue to the jury it meets that factor.
The next one is to slide number 112, and that was slide 111, by the way. 112 is an objection to the slide that says the defendant killed his victims in a manner so that the victims would die surrounded by screaming and pain and anguish.
Correct. Well, I think that the fact that that is the case is not just an opinion on my part. I think that is a reasonable inference based on the evidence. It is, again, the nature of the deaths that he created, that they were surrounded by this horror as it was going on, is an unnecessarily torturous way to commit murder.
The next one, the next objection has to do with the set of slides that starts at number 117 and it goes through 120, and it has to do with consider the victims were unaware of any danger. Consider the victims were unaware of any danger watching a movie. Consider victims unaware of any danger watching a movie helpless. Victims unaware of any danger watching a movie helpless. The defendant was in a place of concealment.
Well, Your Honor, one thing I want to mention is, in this presentation, I really didn't use animations. I wanted to have a record as to what each thing looked like, so I could have just done this as one slide with an animation, but it's just going to be me, these sort of things appearing in that list. So that's why it appears that way. This is my argument as to why this is lying in wait and from an ambush. I think all these factors relate to aggravating factor number 5, lying in wait and ambush. And they show that he did this, he committed these murders, he killed these people where they were unaware of what was coming, and he did it from a place of concealment. And to me, that is the definition of lying in wait and ambush, and this is proper argument based on the evidence.
The last one is to number 123. Consider the victims had no way to know that danger lurked right outside.
Correct, Your Honor. I understand the nature of the term lurked, and I know the case that counsel cited on that. However, that case did not deal with a murder case involving a statutory aggravating factor of lying in wait and ambush. It's a different circumstance. Lying in wait and ambush is not something you would normally have in a murder case. And I think it's proper to describe it that way. However, Your Honor, I can take that out and I can put stood instead of lurked, and I don't think that would really diminish my argument.
All right, anything else from you, Mr. Orman?
No, Your Honor, thank you.
All right, Ms. Brady, I'll give you the last word since it's your set of objections.
Your Honor, I'm not saying Mr. Orman can't argue. I'm saying he shouldn't be allowed to argue with giant PowerPoint slides in big black and white letters up on a big screen TV at a phase 1 of a capital sentencing hearing. He just proved he can very dramatically argue without any slides up on the screen. He could do this entire closing argument in minutes with no slides to the same effect as if he puts up gory photographs and prejudicial slides that are unnecessary to his argument. He simply puts them up there to evoke the sympathy and the emotion of the jury. That's the only reason for those slides. Those jurors have seen the pictures. They're probably seared in their memory. And putting them up again and again during his argument is unnecessary. I would ask that the PowerPoint that the court has be marked as a court exhibit. We'd also ask that Mr. Orman provide a digital copy of the PowerPoint presentation to the court to also be marked as an exhibit. We, I think, previously asked that Mr. Brockler's PowerPoint presentation for his merits closing be submitted to the court, and I don't think that's been done. I know that Mr. King's PowerPoint was submitted to the court. So I just want to make sure that all of those get marked as a court exhibit and put into evidence.
Any objection to that, Mr. Orman?
Your Honor, I think regarding Mr. Brockler's exhibit, I know I talked to one of our paralegals yesterday. They were working on getting that together. I don't know what the current status of that is. For mine this morning, I have it on a disk.
Okay, you don't have any objection to marking it?
Oh, no, not at all. That's why I did it.
Okay.
I mean, and I don't have objection to the one, the printout.
Well, if we're going to mark the disc, I don't know that we need the printout. Ms. Brady, do we need the printout as well if we have the disc?
I would like both to be, we can,
Is this an extra copy that you gave me?
yes, sir.
All right, then we can mark both. So what's the next number, court trial exhibit? So you can mark the disc 94, and then we'll mark the paper copy 95, C-TR-94 and C-TR-95.
So is it okay if I just write it on there, Your Honor?
It's okay.
Okay, I've got it right here.
Great, thank you. You can just tender it to my staff. All right, Ms. Brady, anything else?
Just a couple brief comments. Mr. Orman's argument that Mr. Holmes intentionally created this torturous situation, I think proves our point that that is based on statements that Mr. Holmes made in the notebook and made to Dr. Reed. If you remove Mr. Holmes' statement, there is no evidence of why he created a situation or what situation he was trying to create. But for his statements, the situation is what it is, but ascribing intent to him for specific things come from his statements. So we would again object to that. The court has in the jury instructions in front of it the definition of torturous. What Mr. Orman is arguing to be torturous, I do not believe fits the definition the court's going to read to the jury. His argument that Mr. Holmes knew that there would be young children at the movie theater is unsupported by the evidence, so we would continue to object to that. And I would just remind the court that this is different than the first trial, and I know that the court knows that, but I'm going to keep saying it over and over. So if something happened at the first trial, that doesn't mean it's okay at the second trial, because the court knows that there's heightened reliability when someone's life is on the line, and so if something happens at the first trial, it doesn't make it acceptable or admissible at the second trial, so we're going to continue to object to these things. I'll also put the prosecution on notice anytime they refer to Mr. Holmes as this guy or that guy in the sneering tone that they have been doing throughout this trial. I am going to make an objection in front of the jury and make a record every time they do it. He can be referred to as Mr. Holmes. He can be referred to as the defendant. But this guy is not going to happen at the sentencing, not without an objection from the defense. Thank
Okay.
you.
All right. Well, there has been no objection to that before that I remember, so the people are on notice now that there will be an objection, so they can proceed how they wish. If there's an objection, then I'll hear a response and I'll rule on the objection. All right? I need to take a recess now because we've been at this now for about an hour and 10 minutes, and actually more than that, an hour and a half. And I need to give my court reporter a break. I need to give my staff a break. And I also need to think about some of the arguments that the lawyers have made. In terms of what Ms. Brady was saying about this being different than the first proceedings, she's right, and I'm aware of that. My point simply was, you know, as a lawyer, when you get up and complain about PowerPoint presentations globally in general, and then you get up and use a PowerPoint presentation yourself, then the court's going to take notice of that. And that was my point. I took notice, I noticed that, I made a mental note of that at the time because there was a global objection to the people using a PowerPoint presentation in closing argument, and then Mr. King got up and used a PowerPoint presentation in his closing argument. And it just seems to me you can't have it both ways. The rules apply to both sides, whether it's the trial or whether it's the sentencing hearing. There are rules that I have to apply, and I'm going to apply them based on a way that gives both sides a fair trial, and based on the way that the law tells me I need to apply them. So that was my point. My point was not to imply that this is no different than the first part of the proceedings. Of course it is. My point simply was that not only was there a global objection to PowerPoint slides by the prosecution, but there were specific objections to those slides, and then some of those concerns that were raised by the defense in terms of the people's slides were present in the defense's slides. The people didn't object to them, but they were present, and I noticed them for the first time when they were used in the defense's closing arguments, and it caught my attention. That's all I'm saying. All right, I'm going to take a break, and then I'll give you my rulings on all these objections after the break. The court will be in recess. Thank you.